Good evening, America. This is Jeff Desk. The Department of Justice has now begun releasing the final batch of records tied to the Jeffrey Epstein case. Deputy Attorney General Todd Bland announced that these materials would roll out over the course of the day. The release includes over 2,000 video files and more than 180,000 photographs. Certain portions are so graphic that viewers must confirm they are adults before gaining access. For years, many of those who survived Epstein's actions have called publicly for full disclosure of these records. It ultimately required legislation that passed Congress with overwhelming bipartisan backing to make this information available. Those harmed by Epstein endured profound suffering, and no one should dispute that reality. To the degree that people feel impatient or upset about the process, that reaction is understandable given what has come to light about his conduct. I trust that the dedicated professionals at the department have carried out their responsibilities diligently in recent months. Welcome back, everyone. This is your host, Adam, and today I want to focus on an issue receiving far too little attention. While public focus remains fixed on the latest social media post from Trump or some fresh controversy, a far more significant development is unfolding out of sight. I mean that quite literally. Right now, judges and senior officials are seated in protected facilities, examining documents that ordinary citizens like you and me will likely never view directly. Recent reporting from NPR has uncovered that the Justice Department held back sections of the Epstein materials that reference allegations connected to President Trump. These include references to accusations of sexual misconduct involving a minor, along with certain pages that were excluded from what became public. Members of the House Oversight Committee from the Democratic side raised serious concerns today, suggesting that deliberately concealing such details might cross into criminal territory. We're talking about complete, unaltered records. No obscured sections, no hidden identities, no blocked passages, simply the unfiltered paperwork that names Trump alongside numerous other influential figures. A number of those with access are now quietly sharing observations about the contents, and the picture they describe is troubling. Consider the recent events in New York. A federal judge ordered the Justice Department to correct what he described as major mistakes in how they handled sensitive information in the Epstein documents. Our colleague from CNN, Evan Perez, joins us to discuss. Evan, public curiosity has long centered on whether President Trump's name appears in these records. Now it appears the FBI put together a compilation of claims linked to him as far back as August. What details have emerged? That's correct. During 2025, the FBI assembled a summary of various sexual misconduct allegations directed at the sitting president. Some of those claims date back many years, even decades, and connect in some way to the broader Epstein matter. Of course, the credibility of these accusations remains uncertain. Authorities have indicated that a significant number appear unverifiable, often stemming from hearsay or indirect retellings passed along by others. These Epstein records were meant to clarify the connections surrounding one of the most infamous figures in recent American history. Yet the authorities mishandled the process of shielding private details so severely that personal information belonging to victims, including names and visual material, ended up visible to the public by mistake. It's hard to overstate the gravity of that failure. The department's core duty was to safeguard those who suffered harm while revealing important facts. Instead, they fell short on both fronts. Federal Judge Richard Berman expressed clear displeasure. He directed the government to address the problems immediately, then postponed a scheduled proceeding once compliance occurred after judicial intervention. According to coverage by the BBC, large quantities of the Epstein paperwork were temporarily removed from view following objections from victims that the protective measures had proven inadequate. This goes beyond a minor oversight. It points to deep-rooted problems in the way the Justice Department has managed one of the most closely watched releases of official records in modern times. What makes this especially striking is a recent appearance on CNN by two lawmakers, Thomas Massie and Ro Khanna, on February 9th. After examining the complete, unmodified Epstein files in a controlled environment, they stated their conviction that redactions had gone too far in concealing the identities and ties of at least 6 prominent individuals. Pause and consider that carefully. At minimum, half a dozen influential men whose involvement remains hidden from view. These representatives, having seen the uncensored versions, made plain that the version released to the public falls well short of the complete account. Massie, a Republican representing Kentucky, and Khanna, a Democrat from California, rarely find common ground. Yet both studied the same set of materials and reached the same conclusion. Certain powerful figures enjoy protection, while the broader public stays uninformed. That consensus crosses party lines and underscores a shared belief that authorities are concealing key facts. Turning specifically to President Trump, his name surfaces repeatedly in this context. The Justice Department recently made public approximately 3.5 million pages of Epstein-related material. In the accompanying statement, officials cautioned that portions include unfounded and exaggerated assertions about Trump, some apparently lodged with the FBI shortly before the 2020 vote. So, the situation is this. Vast quantities of documents sit with the government, a number of which level serious charges at Trump. Authorities acknowledge that elements may lack foundation, yet they decline to specify which claims hold weight and which do not. Instead, everything appears with a brief note urging caution, presented as openness. This approach creates a clear divide. Judicial officers review the full scope. Federal investigators examine everything. Select lawmakers gain entry in secure locations. The rest of us receive heavily edited copies with numerous identities concealed and only general cautions provided. We're expected to accept that those with full visibility exercise sound judgment about what deserves public exposure. That said, the absence of public access to unaltered records does not eliminate their legal significance. Judges retain the ability to consider such evidence when weighing criminal prosecutions, civil litigation, or other inquiries, regardless of whether details ever reach the wider audience. When observers inquire whether these materials pose a genuine risk to Trump, the honest response is that the possibility exists. We lack insight into precisely what judicial figures are observing in private sessions. We cannot know what lines of inquiry those millions of pages might open for investigators. What is evident is the unease among certain highly placed individuals at present. The recent judicial directive compelling the Justice Department to repair its handling of redactions, combined with open remarks from congressional members about excessive shielding of influential figures, signals that scrutiny will continue. To grasp the importance of unredacted materials, recognize that they represent far more than paperwork minus a few markings. They determine whether one grasps only fragments of events or comprehends the complete sequence, who participated, the timing, the methods, and any additional parties involved. In courtroom settings, that distinction can separate acquittal from conviction. Official releases routinely involve editing to remove identifying details, dates, places, or other elements deemed necessary to shield for reasons of personal privacy, security concerns, or active probes. Legitimate rationales exist in many instances, preserving a survivor's anonymity or safeguarding sensitive sources. Yet at times these edits serve to insulate prominent individuals from scrutiny or potential liability, and the public has no means of distinguishing between justified and questionable applications. Judges, qualified investigators, and cleared lawmakers see past those barriers. The current release illustrates that divide vividly. Ordinary citizens view a filtered narrative, while key decision-makers access the unaltered version. Increasingly, some of those insiders highlight discrepancies between the two. Massey and Khanna refrained from disclosing specific identities. They remain bound by restrictions, but they emphasize that the disclosed version omits critical context. Their joint stance, bridging ideological differences, reinforces that the issue transcends politics. It concerns institutional secrecy and the public's right to clarity. Regarding the New York mishandling, Judge Berman stated publicly that federal authorities had committed to correcting substantial flaws in their redaction work. In plain terms, the department's errors allowed protected victim information and visuals to surface unintentionally. An agency charged with victim protection and careful document oversight committed lapses serious enough to demand immediate judicial correction. This correction occurred openly, not discreetly. The judge noted satisfaction with the resolution while postponing proceedings, effectively indicating that external pressure proved necessary to prompt proper action. If basic safeguards for victims failed so spectacularly, one must question what other judgments may have gone awry, which identities received excessive concealment to shield those who merit no such consideration. Those are precisely the concerns Massey and Khanna voiced, and they stand far from alone in raising them. The Epstein records extend beyond a single individual. They document an extensive circle of affluent, well-connected figures linked to his activities. The group encompasses survivors, observers, and possibly participants in wrongdoing. Crucially, it involves persons whose stature compels extreme caution from the Justice Department regarding disclosure. What reaches the public has undergone thorough editing, removal, and refinement. In contrast, those wielding real authority, judges, prosecutors, select legislators, encounter the unvarnished account. A growing number now suggests that the authentic version reveals far darker realities than the sanitized one available to everyone else. Massey and Khanna chose to speak openly on national television about their belief that excessive redactions safeguard at least several prominent men. They might have remained silent after their review. Their decision to go public suggests the content struck them as serious enough to warrant raising awareness, even absent specifics. It points to a process that, while ostensibly victim-focused, also appears to guard those responsible for harm. It indicates internal frustration with ongoing efforts to shield accountable figures. The framework for editing sensitive records aims to regulate what becomes known. That function can serve valid purposes. However, when officials concede major errors exposing victims, and when lawmakers openly charge that over-editing conceals influential wrongdoers, the mechanism shows clear signs of dysfunction. The requirement for judicial intervention to compel corrections further demonstrates that the department showed little inclination toward self-correction. Only external accountability produced results. Each instance of concealment, each case of excessive editing, each massive release accompanied by ambiguous disclaimers about fabricated or sensational content fuels the very distrust and theorizing that authorities profess to oppose. Absent full candor, people draw their own conclusions. In a matter involving Epstein, elite networks, and charges leveled at a former president, those conclusions can grow extreme. Greater openness from the government could reduce much of the conjecture. Yet full disclosure carries the risk of real consequences for those in positions of influence, and the prevailing structure tends to avoid such outcomes. Where does President Trump stand amid all this? The answer remains uncertain for now. What stands clear is that judicial officers have examined unaltered records referencing him. The Justice Department acknowledges the presence of allegations against him, while qualifying that some lack substance. Lawmakers have suggested that certain prominent individuals receive undue protection. The justice apparatus continues its private examination of material unlikely to reach full public view. That combination places him in a vulnerable spot. Even absent immediate charges or confirmed validity to any claim, the mere existence of these records, and their review by empowered figures, creates meaningful legal risk. A remote but real chance persists that elements within could support future action. This represents not an imminent threat of incarceration or fresh indictments, but recognition that investigative processes are active. Judicial review proceeds. Investigative work continues. The disparity between institutional knowledge and public awareness harbors potential hazard. In matters of this magnitude, outcomes frequently hinge less on visible developments than on private proceedings. Unfiltered records, restricted sessions, confidential deliberations. Progress here stems primarily from sustained public insistence. Judge Berman acted not out of personal initiative alone, but because victim objections, glaring errors, and widespread concern left little choice. Massey and Khanna spoke publicly because they recognized the depth of public demand for honesty and the consequences of continued silence. Systemic reform rarely occurs smoothly from within. It requires external force compelling accountability. At present, that momentum gathers strength. Fresh accounts of redaction lapses, additional statements from legislators about concealed facts, mounting indications of favoritism toward the powerful, all intensify the demand. Sooner or later, that accumulated force must produce movement. The Epstein materials will remain under scrutiny. Calls from survivors, elected officials, and citizens will persist. So long as a substantial divide separates what authorities examine and what the public receives, legitimate questions about selective protection will endure. President Trump's name appears within these records. Allegations from those who claim harm are documented there as well. Regardless of ultimate veracity, their presence and ongoing evaluation by individuals capable of decisive response ensure that attention to this matter will continue. Stay vigilant. Whenever reports surface concerning flawed protections, congressional pushes for clarity, or court orders compelling further disclosure, recall that beneath those headlines lie concrete documents containing identifiable individuals and specific accusations. Certain names belong to individuals of extraordinary influence. Should any of those accusations withstand examination, the implications could prove profound.